Hi guys, how are you all doing? Welcome back to the channel. This is the House of Law and it's me, Attorney Al Jamrani. In this video, we will continue with the series entitled, Is the Law Biased? For this video, let's talk about the bias in labor law. Ready na ba kayo? Let's go! If you haven't watched part 1, you can watch it by clicking here or clicking the link in the description box below. So in part 1, we saw the different biases in political law, from the bias in favor of human rights as against government restriction, to the bias in favor of local autonomy as against national control, and the bias in favor of the power to tax as against claims of tax exemption. Lilinawin ko lang ha, na ang bias na ito ay hindi special treatment, kung hindi differential treatment. This is justified by the spirit and intent of the law, which is to regulate conduct and to promote a state policy. Also, let's put the term bias in the proper context. Bias here means a presumption or rule of interpretation. Now it's time to look at the biases in labor law. But first, let us define what is labor law. Labor law is primarily concerned with the rights and responsibilities of employers and employees. It comprises of labor standards, labor relations, and remedies. Furthermore, labor cases usually involve enforcement of benefits, dismissal cases, and the right to self-organization. Most of these labor cases, however, involve employees in the private sector. You see, government employees are governed by the civil service laws. Hence, government employees are treated differently as they have different rights and obligations under the law compared to private employees. Also, the remedies are different. Thus, for the purpose of this video, we will be talking about labor law in the private sector. So, I have one quick question and give me one quick answer. If labor law is biased, whose side is it on? Correct, labor or employees. Ano ba ang dahilan kung bakit pro-labor ang batas? Well, una-una, the relationship between employer and employee has never been equal. Hindi patas. It's not a level playing field. The employer always has the advantage or the upper hand. First, the employer creates jobs. If there is no job created, then there is nothing for the employee. Next, the employer decides how much to pay the employee. Of course, the law has set minimum wages and statutory benefits like 13th month pay, but over and above that, it is the sole discretion of the employer. Walang karapatan ng employee na humingi ng salary increase or bonuses kung ayaw naman ng employer. Third, the employer has the power to dictate the manner and method of work. Kung sinabi ng employer na mag-field work ka, hindi ka pwedeng tumanggi. Hindi ikaw ang magdi-decide kung saan at kung papaano ka magtatrabaho. And finally, if the employer has the right to hire, the employer has the right to fire. One day you're working, the next day you could be jobless. That's the reality. However, the law did not create this reality. Bagkus kaya nagkaroon ng batas pang manggagawa dahil sa realidad na ito at upang protektahan ang karapatan at kapakanan ng mga manggagawa. So tamang mindset lang tayo guys. There is imbalance in the relationship between employers and employees. That is why may bias din in favor of employees. Iniaangat at itinataas ng batas ang mga manggagawa so that the employer and the employee can see eye to eye and deal with each other fairly. So let's find out the constitutional provisions in favor of labor. First is Article 2, Section 18, which provides that the state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. Second, Article 12, Section 12, which provides that the state shall promote the preferential use of Filipino labor, domestic materials, and locally produced goods and adopt measures that help make them competitive. And third, Article 13, Section 3, which provides that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. The state shall also guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, human conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. And finally, the state shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. The state shall regulate relations between workers and employers, recognizing the right of labor to its just share in the production of in the fruits of production and the right of enterprises to reasonable returns to investments and to expansion and growth. Ang mga nasabing probisyon ng konstitusyon ay naisa sa katuparan sa pamamagitan ng mga batas na sumasaklaw sa mga manggagawang Pilipino. Andyan ang Labor Code of the Philippines as amended, the Migrant Workers and Overseas Filipinos Act as amended, the Expanded Maternity Leave Act at marami pang iba. Ngayon naman ay tignan natin ang mga karaniwang issue na nakakaapekto sa mga manggagawa at paano nare-resolba ang mga ito ayon sa batas at sa mga desisyon ng korte. So first, in case of doubt in the terms of the contract of employment, kanino dapat pabor ang interpretasyon ng contract? Sagot, employee. It is fundamental that in the interpretation of contracts of employment, doubts are generally resolved in favor of the worker. Any doubt or vagueness in the provisions of the contract of employment should be interpreted and resolved in favor of the employee. Centro Project Manpower versus Aguinaldo na Luis, GR number 160123, June 17, 2015. Second, in case of doubt in the interpretation of the provisions of the Collective Bargaining Agreement or CBA, who should be favored? Answer, employee. As a rule, when the provisions of the CBA is clear, leaving no doubt on the intention of the parties, the literal meaning of the stipulation shall govern. However, if there is doubt in its interpretation, it should be resolved in favor of labor. Wesleyan University Philippines versus Wesleyan University Philippines Faculty, GR number 181806, March 12, 2014. Third, in illegal dismissal cases, kanino dapat pabor ang batas? Sagot, employee. In illegal dismissal cases, the burden of proof is on the employer to prove that the employee was dismissed for a valid cause and that the employee was afforded due process prior to the dismissal. Kaya kung hindi napatunayan ng employer yung basihan at yung tamang proseso, hindi matatanggal sa trabaho ang isang empleyado. Charlie Hubilla versus HSY Marketing, GR number 207354, January 10, 2018. Fourth, pagdating sa pagtimbang ng ebidensya ng employer at ebidensya ng empleyado, kanino dapat nakatikwas ang batas? Sagot, employee. The consistent rule is that if doubts exist between the evidence presented by the employer and the employee, the scales of justice must be tilted in favor of the latter. Case Dominador Malabunga Jr. versus Cathay Pacific Steel, GR number 198515, June 15, 2015. At ang panglima, pagdating naman sa computation ng benefits, kanino dapat pabor ang computation? Sagot, employee. All doubts in the implementation and interpretation of the provisions of the Labor Code, including its implementing rules and regulations, shall be resolved in favor of labor. Article 4, Labor Code as amended. Yan po ang 5 sa mga importanteng presumptions or rules of interpretation in favor of labor. Bias na kung bias ang tawag. Pero paano naman ang mga employer? Wala na ba silang karapatan? Siyempre meron po. Tulad ng sinabi ko sa simula't simula, may karapatan at prerogatives ang mga employer. Bilang ang mga employer ang nagbibigay ng kinakailangang trabaho, pinoprotektahan din sila ng batas. Binabalance lamang ng batas ang interest ng employer at employee. Tulad ng sinabi ng Supreme Court sa Imasen versus Alcon, GR number 194884, October 22, 2014, in protecting the rights of the workers, the law, however, does not authorize the oppression or self-destruction of the employer. The constitutional commitment to the policy of social justice cannot be understood to mean that every labor dispute shall automatically be decided in favor of labor. The constitutional and legal protection equally recognizes the employer's right and prerogative to manage its operation according to reasonable standards and norms of fair play. Kaya sa bawat labor case or issue, binabalanse ang interes ng magkabilang panig. But always, the employer has the burden in these cases or issues to prove that it is right. From interpretation of the employment contract to computation of monetary benefits to the dismissal of the employer should show that it has complied with the law. Dahil kung hindi, remember, nakailing ang batas para sa empleyado. At yan po mga House of Law ang part 2 ng serye na pinamagatang Is the Law Biased? Watch out for part 3 wherein I will discuss criminal law naman. In the meantime, if you like this video, please give it a thumbs up. If you haven't subscribed yet, please subscribe and click that notification bell so that you will be alerted when I upload my next video. See you then. Laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!